Hello students, myself is Parminder Singh from Prab Kirpa classes. We have already uploaded two courses of this chapter. Name of the chapter is Forms of Business Organization. In the earlier two courses, we have learnt about sole proprietorship, partnership, joint Hindu family business and cooperative society. We have already learned that sole proprietorship is a form of organization in which the owner is single, that is, he is the single owner of the business and he is responsible for taking all the decisions. He is he takes all the profits and he also bears all the losses of the business. In case of partnership, two or more persons come together to run a business and their liability is unlimited and they bear all the losses and also share the profits between themselves as per the partnership deed or the verbal agreement. In case of joint Hindu family business, the members of the joint Hindu family are the members and the Karta is responsible for taking all the decisions and his liability is unlimited, whereas all the other members of the joint Hindu family have limited liability. In case of cooperative society, some members when come together to form a society, cooperative society comes into existence. The purpose of cooperative society is not to earn profit but to serve the members. In case of India, Amul is one of the best examples of cooperative society. Now, our today's topic is joint stock company. Now, let us start this topic. In this course, we will discuss what is the meaning of joint stock company, what are its various features. We will discuss what is the meaning of perpetual succession, common seal, artificial purpose, and oligarchic management. We will also understand the merits and limitations of joint stock company. We will understand the difference between public company and a private company. We will get to know the various privileges and exemptions which are given to private companies that public companies do not possess. We will also find answer, is a private company better than a public company, and why some larger companies prefer to remain private. We will also learn, can a private company become a public company? Then why is it important to choose an appropriate form of organization? We will understand the factors that determine the choice of form of organization. Now we will understand the meaning of joint stock company. A joint stock company is a business entity which is owned collectively by its shareholders. The shareholders are the owners of the company. The company is managed on behalf of the shareholders and it is managed by board of directors who are elected by the shareholders in the annual general meeting. The shares of joint stock company can be transferred freely from one shareholder to another person except in a private company. That is, in the case of private company, the shares cannot be easily transferred. A joint stock company is an artificial person. It has legal existence separate from persons composing it. It can sue and be sued in its own name. Sue means someone can file the case against joint stock company and the joint stock company can also file the case against other company or persons. A joint stock company is created by law. It is established for commercial purposes. It has perpetual succession. Perpetual means continuous succession. And it has a common seal. Now we will understand the features of joint stock company. The features of joint stock company are artificial person, perpetual succession, legal formation, common seal, limited liability, separate legal entity, and the number of shareholders. We will understand each of these features one by one in detail. First is artificial person. A joint stock company is an artificial person. Joint stock company is created by law. It does not have the shape or physical form of a human being. It has its own existence in the eyes of law. And joint stock company is independent of its investor. Like natural persons, a company can own property, incur debts, borrow money, enter into contracts in its own name. It can sue and be sued in the court of law. But joint stock company cannot breathe, eat, run, talk, and so on. So joint stock company is called an artificial person. Next is perpetual succession. A joint stock company is the creation of law. It can be brought to an end only by law. It will only cease to exist when a specific procedure for its closure called winding up is completed. Members may come and members may go, but the company continues to exist. Joint stock company remains unaffected by the death, lunacy, or insolvency of any of its investors. Lunacy means foolish acts or mental ill health of the investor. In case of death of the investor, the shares of the company will be transferred to the legal heirs of the investor. Number 3, legal formation. The formation of joint stock company is time consuming, expensive and complicated process. In the case of a sole proprietorship, you can simply set up a board on the shop and you can start the business. But if you want to set up a company, you have to comply with the provisions of the Companies Act 2013 to set up or wind up the company. This is the provision which is applicable in India. Common seal. What is the meaning of common seal? Here, these are the common seals. That is, whenever a company has to sign a document, it cannot sign in itself. So every company has a common seal. Any document which carries the common seal of the company, common seal means stamp of the company, and the paper is duly signed by a designated official of the company, the said document becomes legally binding on the company. Here you can understand from the picture what is the meaning of common seal. Here mostly the name of the company is given in circle and in between there is a logo of the company. Next feature of joint stock company is limited liability. The liability of the members is limited. The creditors can use only the assets of the company to settle their claims. Suppose a person is a shareholder in a company and he is having 200 shares and the shares are of the face value of rupees 10 each. That is, he has invested rupees 2000 in the company on its face value. Now, in the case of default of the company to pay the debts the creditors can only use this amount of 2000. Further, if we take the same example and the shareholder is having 200 shares, but so far he has paid only rupees 6 and the balance of rupees 4 per share is to be paid by the shareholder, then in that case and the company is in default to pay the debts, the shareholders may be asked to the balance amount of rupees 800 rupees, being the amount which is payable by him towards the shares which are being held by him. Beyond this amount, he is not liable to pay anything towards the debts or losses of the company. Separate legal entity. A joint stock company is a separate legal entity. A company can possess properties, it can open its own bank account, it can sue and be sued. Its assets and liabilities are separate from those of its members. Number of shareholders. There must be a minimum of 2 shareholders and a maximum of 200 shareholders in a private limited company. In case of public limited company, minimum number of shareholders is 7 and there is no limit on the maximum number of shareholders. For example, there are more than 33 lakh shareholders in Reliance Industries Limited. We may add that we have already uploaded various courses such as email writing, future tense, past tense, present tense, cybersecurity, most common mistakes in English grammar, letter writing, DBMS, information technology, and much more. You can look out for the same on Google, YouTube, our own website, Udemy, Tutorials Point, etc. Now we will understand the merits of joint stock company. Its merits are limited liability, transfer of interest, perpetual existence, professional management, greater scope for expansion and economies of scale. We will discuss each of its merits one by one. First is limited liability. The shareholders are liable to the extent of amount unpaid on the shares held by them. As already told, if we are having 200 shares of a company and the face value of the share is rupees 10 and we have so far paid only rupees 6 and the balance amount payable per share by us is rupees 6 is 4, then in case of default of the company or in case of the winding up of the company, the shareholder is liable to pay the balance amount of rupees 4 which is unpaid, being the amount which is payable on the shares held by him. The owner's personal property, that is his car, his house, etc., cannot be called to meet the company's liability. Shareholders are responsible for the debts of the company only to the extent of the face value of their shares in the company. That is, this is face value and the shareholder will be liable only to up to the extent of this amount. Next is transfer of interest. The shares of a public limited company are freely transferable and can be sold and purchased through the recognized stock exchange. Members can transfer their interest to others without any restriction from other members. Next merit of joint stock company is perpetual existence or continuous existence. Existence of a company is not affected by the death, retirement, resignation, insolvency, or insanity of its members. Insanity means mental illness. The members may come and members may go, but the company will continue to exist as it can be liquidated only according to law, that is as per the provisions of the Companies Act 2013 in India. That is, this rule is applicable only in India. Next, professional management. A company can afford to pay higher salaries to specialists and professionals, so it can hire professional persons to run the various posts. Professional managers are able to show better results in the business. Then there is greater scope for expansion. In the case of a joint stock company, a company can get huge capital for the business through issuance of shares, debentures. It can also avail loans from banks and financial institutions. Due to huge capital availability, there is greater scope for expansion of business. Next feature is economies of scale. A company operates on a high scale, and so it has good bargaining power and enjoys economies of scale. Now we will understand the limitations of joint stock company. Its limitations are complexity in formation, lack of secrecy, impersonal work environment, numerous regulations, delay in decision making, oligarchic management, and conflict in interest. We will understand each of its limitations one by one. First is complexity in formation. The formation of a company requires greater time, effort, and extensive knowledge of legal requirements and the procedures involved. Next limitation is lack of secrecy. It is difficult for the public company to maintain complete secrecy about the operations of the company because it is compulsory for the company to publish accounts and other records. Next, impersonal work environment. In some companies, there is lack of effort on the part of the officers of a company. Further, the large size of the company makes it difficult for the owners and top management to maintain personal contact with the employees, customers, and creditors. Next point is numerous regulations. The functioning of a company is subject to many legal provisions and compulsions in respect of audit, preparation of accounts, documents, etc. The company is also required to obtain various certificates from different agencies, viz. Registrar, SEBI, etc., or it may be SEC in the case of USA. This reduces the freedom of operations of a company and takes away a lot of time, effort, and money. Then another limitation is delay in decision making. Companies are democratically managed by the board of directors. Down the line comes top management, middle management, and lower level management. Communications as well as approval of various proposals may cause delays not only in decision making but also in acting upon them. Some decisions require shareholders' approval in the annual general meeting. Another limitation of joint stock company is oligarchic management. Now, what is the meaning of oligarchic management? It means rule by few or management in the hands of few. In theory, a company is a democratic institution where the board of directors are the representatives of the shareholders and the shareholders are the owners. However, in practice, it happens that in most large size companies, the shareholders are spread all over the country and a very few percentage attend the annual general meetings. As such, the board of directors enjoy considerable freedom in exercising their powers and they sometimes use these powers even contrary to the interests of the shareholders. Dissatisfied shareholders in such a situation have no option but to sell their shares and exit the company, as the directors virtually enjoy the rights to take all the major decisions. It leads to a rule by a few. Next limitation is conflict in interest. There may be conflict of interest amongst various stakeholders of a company. For example, the employees want higher salaries, consumers want higher quality products, and that too at lower prices. Shareholders want higher returns in the form of higher dividends, and they also want increase in the intrinsic value of their shares. These demands give rise to problems in managing the company as it often becomes difficult to satisfy such different interests. Now, our topic is types of companies. A company can be either a private company or it can be a public company. These two types of companies are discussed here in detail in the coming paragraphs. Private company. Private company means a company whose stock is not publicly traded on the exchange. Exchange means stock exchange. Private company is a company which is formed by a small number of shareholders. The number of shareholders minimum is 2 and the maximum is 200, excluding the present and past employees. The shares of a private company are offered, owned, and exchanged privately and are not traded on a public stock exchange. The shares of a private company are less liquid. That is, the shares of the private company cannot be easily or quickly sold and turned into cash. And the valuations of the shares of the private company is more difficult to determine. Private company restricts the rights of the members to transfer its shares. What are the advantages of private companies? Number one, disclosure of revenue and profits to the general public is not required. There is no pressure associated with meeting quarterly earning expectations. Next, disclosure of salaries and benefits of corporate officers to the general public is not required. It is necessary for a private company to use the word private limited or pvt.ltd. After its name. If a private company contravenes any of the above provisions, it ceases to be a private company and loses all the exemptions and privileges to which it is entitled. In the case of India, private companies enjoy certain privileges and exemptions as have been granted to them by the Companies Act. So let us read what are those privileges and exemptions which have been provided to private companies and not to the public companies members. A private company can be started by two persons only, whereas in the case of a public company, 7 people are needed to start the company. Prospectus. A private company is not required to issue a prospectus as public is not invited to subscribe to the shares of a private company. What is the meaning of prospectus? Prospectus is a document which gives the details of the financial particulars as well as its directors, location of its offices, as well as various litigations which are going on at present or at the time of issuance of IPO. Prospectus is published by the public companies at the time of raising capital from the market. Next, directors. In the case of private company, the minimum number of directors required is only 2, as against the minimum number of 3 directors in the case of a public company. However, the maximum number of directors for both types of companies is 15. Commencement of business. A private limited company can start business as soon as it receives the certificate of incorporation. Quorum. 2 members personally present is sufficient quorum for the general meeting of a private company as against 5 members for public company. Index of members. A private company is not required to prepare and maintain an index of members, while the same is necessary in the case of a public company. Report for AGM. There is no need to prepare a report for the annual general meeting in the case of a private company. Independent directors. There is no need to appoint independent directors in the case of a private company. Functioning of private companies. Private companies function mostly in the same way as public companies. Both produce goods or services to generate profits, but the main differences in both the companies lies in their issuance of company stock, financial disclosure obligations, and reporting requirements. Now we will understand what are the various examples of private companies. Many well-known companies are private companies. For example, services companies, that is accounting firms, Deloitte and Price Waterhouse Coopers. Supermarket chains like Publix and Cargill, producer and distributor of agricultural products worldwide. Now a question arises, is a private company better than a public company? None of the two is better nor worse. Public companies may choose to become public companies later if they need additional capital. If a private company wishes to sell shares to public to raise funds, the process of raising capital is called an initial public offering and the company turns into a public company. Why do some larger companies decide to remain private? Some larger companies may decide to remain private due to following reasons. First is lot of regulatory compliance. Public companies have to deal with a lot of regulations and the public companies have to file financial reports regularly. Next point is going public is expensive. Floating of initial public offering is neither easy nor cheap. It is a very complex process which involves a large number of bankers, lawyers, accountants, and providers of data. Next point is lack of secrecy. As a listed firm, your competitors will know much more about your company's margins, pricing, profitability, and financial structure. Next point is fluctuating stock prices. Even if your company is doing well, its share price could plummet if it is listed on a stock exchange when the overall economy takes a downward turn. It can be understood with the help of an example. If your company is listed on this stock exchange and in 2020 there was coronavirus, it spread the world over. The shares of all the public companies had fallen sharply on the stock exchanges. It had no relevance with the performance of the companies. So even though the companies were doing well, the shares were had fallen because the overall economy had taken the downward turn. If the employees own shares, a declining stock price could destroy morale of the employees. How to become a public company? For a company to become public, it launches an IPO. On the day of the IPO, it converts from a private into a public company. Businesses generally use IPOs as a means to raise money. Sometimes the directors may decide to go public so that the workers, owners, and early investors can cash in their shares. Some public companies go private. Public trading companies can revert to become private companies again if enough shares are purchased from the shareholders. Now, next point is public company. What is the meaning of public company? A public company or a public limited company means a company which is not a private company. The shares of the public company are owned by many investors. The shares are traded on public stock exchange. The company is required to disclose its financial and business information regularly to the public and also to the various regulatory authorities. Public companies have access to the financial markets and they can raise money for expansion and other projects by selling stock or bonds. As per the Companies Act in India, a public company is one which has a minimum of 7 members and there is no restriction on maximum number of members. A public company has no restriction on transfer of securities. A public company is not prohibited from inviting public to subscribe to its securities. However, a private company which is a subsidiary of a public company is also treated as a public company. Now we will understand the difference between a public company and a private company. In the case of public company, the minimum number of members are 7 and maximum is unlimited. In the case of private company, minimum members are 2 and the maximum are 200. In the case of a public company, minimum number of directors are 3 and in case of private company, the minimum number of directors are required are 2. Listing of the shares. The shares of the public company are listed on the recognized stock exchange, whereas the shares of a private company are not listed on any stock exchange. Shares of a public limited company can be transferred easily, whereas the shares of private company cannot be transferred easily. In the case of a public company, the management has to follow the rules and regulations of the company, so it is quite rigid and inflexible. In the case of private company, owners themselves are the managers of the company. Management lies in the hands of the owners, so they are more flexible in taking decisions as per the situation. Next, public company can invite the public to subscribe to its shares, whereas private company cannot invite the public to subscribe to its shares. Index of members is compulsory in the case of a public company, whereas in the case of a private company, index of members is not compulsory. Now our topic is factors affecting the choice of form of business organization. So far, we have studied the various forms of business organizations and we have gone through the merits and limitations of each form of business organization. And we have to keep in mind the merits, demerits of different types of organizations, and only after that we can decide which form of business organization is better if we want to start the business. So what are the various factors which influence the choice of form of business organization? First factor is cost of formation. If we go through cost of formation, it is very easy and it is very cost effective if we want to set up a sole proprietorship. For example, if we want to set up a grocery shop, we can open the same if our house is suitably located, or we can start the grocery shop in a small area. Whereas if we want to start the company, it is very much expensive. It requires a lot of capital. If we want to set up sole proprietorship, it is very easy, but it is very complicated process or time consuming process if we want to set up company. Further, in the case of sole proprietorship, there are minimum regulations which a sole proprietor has to follow. Proprietor form, a partnership form of business has to follow certain other rules. But in the case of company, a large number of regulations have to be followed. In the case of sole proprietor, he himself takes all the decisions. He is flexible enough to take the decision on the spot as the situation warrants. But in the case of the company, a set of rules have to be followed. So it is inflexible to take decision in the case of a company. Availability of the capital is enormous in the case of a company because it can approach the public by way of IPO. But in the case of sole proprietorship, even the banks may not grant any loan to the sole proprietor. So the availability of capital to the sole proprietor is limited. However, in the case of partnership, many partners come together and pool their resources such as land, capital to start the business. In the case of the company, even if there is a death or retirement or insanity of the shareholder, the business continues. In the case of partnership, it is somewhat affected by the death of the partner. But in the case of sole proprietor, if the sole proprietor dies, the business comes to an end. In the case of liability, company's most advantage has most merit in its case so far as liability is concerned, because the liability of the shareholders is limited, whereas the liability of the sole proprietor is unlimited. That is, its personal assets can be attached to pay off the liabilities of the business. In the case of company, it can hire specialists and professional managers from the market because it has enough capital. The partners may differentiate the work among themselves. However, they may not be in a position to hire the specialists to manage the various jobs. Same is the case with joint stock company or cooperative societies. Cooperative societies also cannot afford to hire specialists by paying hefty salaries. In the case of sole proprietor, he himself takes all the decisions, so he may lack managerial skills. In the case of public company, transfer of interest is possible easily. whereas in the case of partnership, transfer of ownership is not possible or it is difficult. Now we will discuss all these factors one by one. First is cost and ease in setting up organization. As far as initial business setting up costs are concerned, sole proprietorship can be set up easily and the cost involved in setting up a sole proprietorship form of business is very less. In the case of partnership, less legal formalities have to be complied with, lower cost is involved, whereas cooperative societies and companies have to be compulsorily registered with the authorities concerned. If we want to form a company, it involves a lengthy and expensive legal procedure. So, from the point of view of initial cost, sole proprietorship is preferred form as it involves least expenditure. On the other hand, company form of organization is more complex and involves greater costs. Liability. In the case of sole proprietorship and partnership firms, the liability of the owner and partners is unlimited. This means that paying the debts of the business from personal assets of the owner or partners. In the case of joint Hindu family business, only the Karta, which is the eldest member in the family, has unlimited liability. In the case of cooperative societies and companies, however, liability is limited. So, from the point of view of investors, the company form of organization is more suitable as the risk involved is limited. We have already discussed that if the company goes into liquidation, the liability of the shareholder is only limited to the extent of the face value of the shares and the total amount invested by him in the shares so far as its face value is concerned. Continuity. The continuity of sole proprietorship and partnership firms is affected by the events such as death, insolvency, insanity of the owner or partner. However, such factors do not affect the continuity of business in the case of organizations like joint Hindu family business, cooperative societies, or companies. In case the business needs a permanent structure, company form is more suitable. For short term ventures, proprietorship or partnership may be preferred form of business organization. Management ability. If the organization's operations are complex in nature and require professionalized management, company form of organization is better alternative. If the business activities are simple and even people with limited skills are able to run the business, proprietorship or partnership may be suitable. Next is amount of capital required. For medium and small sized businesses like laundries, workshops, where capital requirement is less, one can opt for partnership or sole proprietorship. Large scale enterprises where large financial resources are required, they can be organized more successfully as private or public companies. Next point is government regulation and control. Proprietorship and partnership form of business are subject to little regulation and control by the government. Companies and cooperatives are subject to many restrictions and they have to publish their accounts. It is easy to maintain secrecy of business in case of sole proprietorship and partnership form of business. Degree of control. If a person wants direct control over operations and absolute decision making power, sole proprietorship may be preferred. But if the owners do not mind sharing control and decision making, partnership or company form of organization may be adopted. Nature of business. If direct personal contact is needed with the customers, such as in the case of a grocery store, tailors, proprietorship may be more suitable. In the case where services of a professional nature, such as tax consultants, lawyers, doctors are required, partnership form is more suitable. Large size manufacturing organizations are commonly set up as private or public companies. Now here we will do the comparative evaluation of different forms of organization. First is formation. Sole proprietorship form can be easily formed and minimum legal formalities are required to be fulfilled. In the case of partnership, it is easy to form the partnership form. Registration is optional in the case of partnership. It is easy to form joint Hindu family business. Less legal formalities are there and there is exemption from registration. In the case of cooperative society, many legal formalities have to be complied with and registration is compulsory. In the case of company, it is a very time consuming and lengthy and expensive process has to be followed and registration of the company is compulsory. In the case of sole proprietorship, only owner is all in all. In the case of partnership form of business, minimum two partners are required and the maximum partners can be 50. This is relevant in the case of India. In the case of other countries, the number of members may differ. The joint Hindu family business is found only in India and at least two persons are required for division of family property. In the case of cooperative society, if we want to set up a cooperative society, at least 10 adult persons are required. There is no maximum limit on the number of members of a cooperative society. In the case of a private company, minimum number of shareholders or members are 2 and the maximum are 200. In the case of a public company, minimum number of members are 7 and maximum there is no limit. As already told, Reliance Industries has 33 lakh shareholders on its rolls. Capital contribution. In the case of sole proprietor, all the capital is managed by the sole proprietor, so the availability of capital is limited. In the case of partnership, the availability of capital is somewhat more than the sole proprietor. Joint Hindu family business has ancestral property. In the case of cooperative society, the members who have limited means come together and they form the cooperative society, so the capital available at the disposal of the cooperative society is limited. In the case of company, enough capital resources are at the disposal of the company. Liability of the sole proprietor is unlimited. In the case of partners, it is unlimited and joint, that is, they are jointly and severely responsible for the debts of the company. In the case of joint Hindu family, Karta has unlimited liability, all the other members of the family have limited liability. In the case of cooperative society, its members have limited liability, and in the case of the company, the shareholders have limited liability. In the case of sole proprietorship, he takes all the decisions. In the case of partnership, control and management lies with the partners. In the case of joint Hindu family, Karta takes all the decisions on behalf of all the members. In the case of cooperative society, there is a management committee which takes all the decisions. Members of the cooperative society choose the management committee on the basis of one vote, one person, one share, one vote. In the case of the company, there is separation between ownership and management because there is board of directors who manages the affairs of the company. In the case of sole proprietorship, it may come to an end with the death of the company. So partnership form of business is more stable than the sole proprietorship. In the case of joint Hindu family business, if the Karta dies, the next eldest member in the family becomes the Karta and he manages the affairs of the business. In the case of cooperative society, it is stable because it has separate legal status as than its members. In the case of the company, it is stable because it also has a separate legal entity different from its shareholders or members. Now we will conclude this chapter. So far we have discussed different forms of organizations which differ in ownership and management. The major form of organizations which we have discussed are sole proprietorship, partnership, joint Hindu family business, cooperative society and company. Sole proprietorship form of business is a business which is managed by a single person. He brings in all the capital, though he may not be in a position to get enough capital as the banks are reluctant to provide any capital to the sole proprietors. He takes in all the profits and he's also responsible for bearing the all the losses incurred by the sole proprietorship. In the case of partnership, many persons come together to form the partnership. They bring in capital and other resources and they share the profits and losses in the agreed ratio. The partnership agreement may be verbal or it may be in written. It is suggested that written partnership deed should be there so that in case of any dispute, the same can be resolved easily. In the case of joint Hindu family business, the members of the joint Hindu family are the members of the business. The Karta is the main person who is the eldest member in the family is the Karta and he manages all the affairs of the business. He has unlimited liability whereas all the other members of the joint Hindu family have limited liability. As per a recent judgment of the Delhi High Court, even a woman can become the Karta. Next, cooperative society. A cooperative society is a voluntary association where many persons may come together to form a cooperative society for the benefit of the all. The main purpose of the cooperative society is not to earn profits, but its main purpose is to serve the members. The various forms of cooperative society may be consumer cooperative society, it may be producer cooperative society, it may be farmers cooperative society. In the case of India, Mool is the best example of the cooperative society which has made tremendous progress in the past. In the case of company, joint stock company is an artificial person. It has its legal existence. It can sue and be sued in its own name. Joint stock company can be private company or a public company. In the case of private company, its shares cannot be transferred easily, whereas in the case of a public company, the shares are listed on the stock exchange and can be easily transferred. Now, question comes that which is the best form of the organization if we want to start a business? Selection of a particular form of organization has can be made only after taking into consideration various factors. The factors may be initial costs, liabilities, continuity, capital considerations, managerial ability, degree of control, and nature of the business. And after taking into account all these factors, we can decide which type of particular form of business, form of organization is better for us in a particular situation. If you like our video, please like, share and subscribe our channel. Thank you.